to another edition of the LTC webinar series. My name is Brian Bates. I'm the Director of Professional Learning with the Learning Technology Center. I'm joined today by my colleague, Matt Jacobson, Online Learning Coordinator. He'll be helping me out in the chat and moderating and helping get your questions answered throughout today's sessions. Before we get started, just a couple of quick reminders. First, we are recording the session today. It'll be available on our YouTube channel in about 24 hours. So check back tomorrow afternoon, our YouTube channel, if you would like to see the recording again, or feel free to share it out with someone you know who may have missed today. Also, if you do have questions today during the session, we highly encourage you to submit those using the chat feature. Just make sure you choose the drop-down menu for everyone, so that way we all get to see your question and we can all learn from the responses and the questions that are being asked. And finally, those attending live today will receive an email tomorrow afternoon with an evaluation to receive evidence of completion for professional development hours for attending. So without further ado, I'm going to go ahead and turn it over to today's presenter, and I'm really excited to have back a presenter that's been with us before. It's that time of year again for an update. And so Attorney Brandon Wright is joining us today to talk a little bit about some school law updates as far as data privacy, SOPPA, and technology. So Brandon, welcome back. And whenever you're ready, feel free to take over the show.
Thanks so much. Glad everybody could hang out with us today and really think through all of these tech-related issues that are out there, in school law for us going on right now. And so, please don't be shy as we walk through our time, together today to be able to, think through and think about some of these issues. Because I certainly have my list I've put together sort of a top 10 list of issues that I want to make sure we're thinking about and they're on our radar as it relates to those tech issues, but certainly your questions are important for us. I did just pop a link to the PowerPoint in the chat box, so that's there for everybody as well as we jump through. But the biggest part of what we're going to spend the first half of our time talking about are really some of these data privacy issues that are so important for us. We know, and you all know, in your school districts, that we are dealing with not only changes in the law when it comes to data privacy, but a number of those attacks going on. 2020 was a record-breaking year for school hacks, and those cybersecurity issues are so important. Not surprisingly, that sort of aligned with people working remotely, going to school remotely, remote learning. And so we just want to make sure that we're keeping in mind some of those really key features for us that are out there when it comes to data privacy. And of course, a huge piece to that is making sure that we're getting those SOPPA amendments fully implemented and continue to go on. And so I just, my plan today is not to give you a lesson in SOPPA. That stuff's out there from LTC. They're doing a great job on that. There's lots of resources, but I want to hit some of the little details, some things that we're seeing going on, as well as some of those other issues that are out there for us. So when we're thinking about some of the policy issues and the written agreement issues and implementing those reasonable security measures, again, my plan today is not to go back and give you the basics of that, but to jump in with some of those practical things that we're seeing from our end being an issue. Then we want to talk about some web accessibility issues. We want to talk about social media in light of the Supreme Court decision this summer. So we've got a bunch of tech stuff to think through today. And I have, as I like to sometimes do, organized that in a top 10 list. What are those top 10 tech issues that we all need to have on our radar right now? And I think, number one here is a pretty big overarching umbrella statement. But we want to make sure that we are training and communicating with all of our employees about SOPPA and our data privacy practices. One of the things that I really emphasize is that within those reasonable security practice and procedures that have been identified by the LTC, blessed by ISB, training your employees on that is a key component of that, is a significant aspect to those reasonable security practices. And so training all employees on being awareness of data privacy issues, of that secure authentication, identifying social engineering attacks, handling sensitive data, talking about that unintended data exposure where we've made mistakes like the accidental reply all or emailing the wrong person, and how we report those incidents and move forward when we do have a breach of cybersecurity. That training piece and that communication piece is so important. And so it needs to be something that we are prioritizing among the professional development and training activities that we're doing for staff. And again, for all staff, right? Not just teachers, but our secretaries and aides and anybody else who's using our tech in the school district. That's really important so that they understand some of the basics there, making sure that we are using pre-approved SOPPA compliant platforms for anything that's going to use covered information or student data. And I'm not sure, as I've lived through this first semester of the school year, that in all districts we've communicated that message sort of beyond the need to know. Because I think, frankly, the need to know is everybody, so that everybody knows why the policies are in place and why the limitations are there. So it's not a free-for-all in terms of downloading apps and what we're using, so that all employees understand, the limitations on only being able to use approved operators, implement those reasonable security practices, including and particularly when we might be accessing the school's network away from school, and following those updated policies. So I really think there's a key training component here to meeting our compliance. And we don't want to overlook that as part of what we're doing and working through in that regard. So number one thing we've got to be doing is having that conversation with all of our employees about some of those basic issues. Number two on my top 10 list this afternoon is, picking out some of those key things that are in the press policies and procedures. And again, I assume most of your districts, are press subscribers, and most of us are using some of those default policies and procedures that were created by press. And I think they do a great job. And so I think that sometimes what happens for us is that we adopt the policy of procedures, but we don't really read what it says and recognize that in many of those situations, there's some immediate responsibilities for us in terms of making sure we're meeting those requirements and how we're going about doing that. And certainly the way to the press policies and procedures explain it, the process that it sets up is not the only way to do it. But if we've adopted that policy, if we've adopted those procedures, then certainly we want to be mindful of that. And so to meet the requirements, the press policy and related procedures for that was policy 7345. And there are multiple exhibits and administrative procedures attached to policy 7345 that create a few responsibilities that I want to make sure that we're not overlooking. One of those things that it notes is that the superintendent or designee designates which district employees are authorized to enter into written agreements with operators for those contracts that don't require separate board approval, meaning we don't have a bid requirement or the amount of money being spent or under that board threshold. And so there is a responsibility there for the superintendent or designee to do that. And that's then noted in the administrative procedure. So within the administrative procedure attached, it then has the superintendent specifically list those employees that are so authorized. And I raise this just because I've had conversations with a number of districts this semester where we go and look at their administrative procedure and those lines are still blank, right? That the superintendent or designee has not designated which employees are so authorized. And so I think it is important to recognize that we take a step back and look at those procedures that we're following through on that. And of course, as part of that we're maintaining those reasonable security procedures and practices. Do we have those in place? Can we check through those and make sure that we've met those, that we're requiring it? But also recognize that administrative procedure also establishes an educational technology committee. And that it tasks either the superintendent or someone designated as the privacy officer to establish that committee to evaluate which online applications or other educational technologies are going to be approved for use, establishing the list and developing that process for approving them. And again, I think that a lot of us haven't taken that step of saying, oh goodness, adopted a procedure that says we're going to create a committee that's going to do these things. And so I want to make sure that we're not overlooking some of those key actions that are there. And again, there's very detailed step-by-step actions in those press procedures. And so for those districts that are press subscribers, you have all of that. But I just want to point out those few things that are there for us, because there are some responsibilities embedded within the procedures that many of you have adopted, whether you intended to or not, with roles for the privacy officer and for that ed tech committee. And so don't overlook what might be there as it relates to that. Number 3, keep up to date when you get those agreements in place and post them on the web. You know, we've got to have a written agreement with each operator that's used by the school that uses covered information. For many of them, the LTC's system through the Data Privacy Alliance is one that we certainly have recommended. So good job, LTC, for making everyone's life a lot easier. I know this was a ton of work for you all, and I know so many of my clients appreciate and are utilizing what you all have put together to help manage those written agreements. And so that's certainly a great thing. A couple other points that I do want to point out to when we're getting these agreements in place. You know, if an agreement doesn't have, or an operator doesn't already have an agreement through the Privacy Alliance, then, you know, you can use the National Data Privacy Agreement. I think there's going to be a committee that's updating the Illinois National Data Privacy Agreement at some point, probably in the coming months or so. But that is out there, and that's what we see a lot of operators. You know, we're using that standard sample agreement for that purpose. But as we've looked at so many of those, I do just want to point out this particular word of caution, that a lot of operators are trying to chip away at some of those provisions by attaching an exhibit that changes those standard provisions in ways that I think might not be fully compliant with the SOPPA requirements. And they vary, right? It's not that they're all doing the exact same thing, but of course they're all trying to have their lawyers write some fancy language that comes into play and makes that an issue for us that we want to recognize what that means for us. You know, for one, it says, well, we're going to only follow the key provisions. So, well, that's ambiguous, right? And not fully compliant. And we just want to be really careful about some of that language sneaking in that might not be fully compliant, or that excuses the operator from that full compliance. So really make sure you're continuing to look closely at those additional addendums or exhibits that are being attached to the standard agreement that's out there. And I want you to keep that in mind. But as we work through and think through these issues, we certainly need to recognize that data privacy is not only a SOPA issue, right? That we've got multiple statutes at the state and federal level that require us to meet some basic confidentiality and, by extension, data privacy requirements. You know, at the federal level, we've got COPPA. We've also got, you know, what we all know very well, FERPA and the Student Records Act, that require us to maintain confidentiality of student records. And so that's why I've certainly encouraged districts that as we think through certainly the issues that are out there for us under SOPPA, that we don't want to get too hung up on, you know, the definition of covered information or those specific requirements, because there's a broad duty that exists otherwise, pre-existing these changes in state law, that as a school district, we have an obligation to keep student information and student data private, and that means maintaining reasonable security. That means not sharing information outside of the FERPA circle of trust. Right? So I do think it is essential that as we think through those issues, that SOPA is not the only avenue that creates rights and responsibilities for us when it comes to data privacy and cybersecurity. And so I just, you know, we could spend a whole hour just starting to unpack the issues that are there under FERPA and the Student Records Act. But I think that we get so laser focused on the most recent change in the law, and that certainly is SOPPA within the state of Illinois. But a lot of those obligations, maybe not the posting it on the website piece and the specific agreement piece and those things that certainly are much more specific and much more narrow requirements. But the broad requirement that if we've got a data breach and it's sharing student information, that we've got a FERPA issue or student records issue at hand, that's certainly there for us as well. So I don't want us to get too laser focused on SOPA being the only consideration when it comes to data privacy, and that we've got other legal requirements that sort of layer upon it, sometimes sort of concurrently, but those are not always simultaneous matters. So we want to keep that in mind. And then, I want to spend a few minutes really thinking about the ransomware attacks. I mean, that's one of the things that, in the regional security practices that are recommended by ISB and the LTC are that we've got training for these social engineering attacks and related ransomware attacks. These are certainly becoming more sophisticated, more frequent. We see a significant number of them, and a significant number of them towards school districts, right? And ransomware, I presume most of us participating today, are folks who, have a relationship with technology that you know what ransomware is, but basically it's a virus or other malware that literally, asks for a ransom, right? That they're locking down your data or your system, wanting a payment for money in exchange for that. And certainly those come in lots of different forms. But certainly we want to make sure that we are being prepared for that. And that's an area of training. And we've seen that, in ways, over the last year that have gotten a lot of attention. Remember the Colonial Pipeline attack, those kinds of things are exactly what we see out there, that also are happening to school districts. There were over 400 publicly disclosed. Now, how many were not disclosed? Cybersecurity incidents against school districts involving ransomware in 2020. Last year, these are big deals. This case, if you look at that article, can look at an issue where a Texas school district, had right before school started, ransomware locked down the system, and they actually had to delay the reopening of school, not start school on time because of that. But they had some of the right measures in place to quickly contain that threat, back things up, and move forward. But we need to really be ready for that. And I think helping our employees truly understand how to identify these, how to be those savvy consumers. I think about all the conversations I hear, the phone calls I get from my mother, like, hey, Brandon, I got this link. I don't know what it is. It's asking me to put in my information. I'm like, is this a scam? Is this not a scam? And being able to identify that is really important. And, we see a lot of these phishing attacks, where it looks like it's coming from something that's reputable or appropriate, trying to trick us into clicking a link or open a file that's going to, download that ransomware onto our device or our network, and we see that starting to take other forms, going after the big fish, that CEO fraud or whaling, where you're going after the superintendent or somebody else to get more sensitive data, more targeted phishing attacks. But what we're really seeing that sophistication increase are what are called these social engineering attacks, where hackers are really taking the time to look at websites, look at social media, to make it look more legitimate, that it's coming from your friend, that it's coming from your coworker, that it and so we certainly see significant increases in that, and we need to be able to, and we need to actually train our employees to be able to identify that and avoid it, and think about that. And ultimately, I think the bottom line is we need to make sure that employees are trained to know that if you get an email with a weird link, don't click it, don't open the file. And a lot of times you can do sort of that that link hover, where you can kind of, without clicking the link, hover over the link to see where it's actually taking you. And is it taking you to a weird space you don't know? Are things spelled wrong? Those are the kinds of things, is it Facebook with an extra O in it, or, those kinds of things sometimes are more obvious. Sometimes they're getting more sophisticated than that, but we need to be prepared for that, and then have a plan, of course, in case it happens, so that we have actually activated a response plan. There's a number of resources out there. One that I share here, the National Institute of Standards and Technology have a computer security incident handling guide. That's something that NSBA, the National School Board Association, as long as it continues to exist, has recommended as a starting place. That's about an 80-page document. I mean, that's not just a checklist. That's a pretty detailed dive into what needs to happen to be able to stop an attack and prevent it in the future, and the response to that. So we just want to make sure that as part of our planning is being fully prepared for those situations, and being ready to move on and think about where we go from there. So let me pause here for a second. If you guys have questions, in the chat or the Q&A, and happy to do that. Because, our first half of our time together, we've really focused on that data privacy piece. We're going to jump into some other tech issues that are out there for us in the school world here in our second half of our time together. Now, let's see if there are some specific questions or issues that you all are seeing on that data privacy front, or with your implementation of SOPPA, that you want to spend a couple minutes thinking through a little bit further, or you want to pick my brain about. I think that would be helpful. So let's see if anybody's got anything you want to pop in the chat or ask, and we can talk about that further. But I do think it is important that this is a topic in an area that, as technology continues to move forward at lightning speed, we've got to make sure that our security practices are equally keeping up with those changes in technology to protect the data that we have. I think one of the things that's also important is I have a little bit of concern that we all, we spent the summer of 2021 really getting all of our stuff in place in terms of SOPPA, but that's an ongoing obligation and ongoing efforts. And we want to make sure that we're not just limiting ourselves to, hey, we complied to the beginning and then sort of put it out of sight, out of mind. I think that's really important. Question here, would you suggest that phishing training be incorporated into other types of required trainings that employees do at the beginning of the year? I do. I mean, one, I think that we look at training on things like social engineering attacks are specifically noted within the reasonable security practices. And so finding ways in order, to incorporate those in training, I think is important. I have a love-hate relationship with mandated trainings because often they are important, but employees don't always give mandated trainings the same attention that we do other things just because it's a good idea. So there's a balance there, but I do think that that's when we look at the training components that are recommended in the reasonable security practices that have been identified for SOPPA compliance, training on phishing and social engineering attacks are specifically listed and included. So we've got to make sure we're finding a way to train employees on that. That's really important. Do you have suggestions for companies that could do an audit of our security measures? Well, I'm not really here to promote particular products. I know many school districts have used, different companies. There are multiple companies that are out there. I haven't been the one on the front lines, to say that one is better or not. There are several of them out there. The one word I would say from some of the tech directors I've talked to in different school districts is that with the free ones, you get what you pay for. But some of the ones that do cost a little bit of money to do that they are beneficial. So I don't necessarily have the names of those companies here at my fingertips. I could probably find them if I needed to dig into them. But I don't have personal experience necessarily with them, but I do have some client districts that have some that they have found to be helpful out there for us. What's the status of talks with Google on SOPPA compliance? Well, I'm not on the front lines of those negotiations, so I can't tell you exactly where things stand, other than I know those efforts continue. Everybody's continuing to use Google. I mean, I don't know anybody that stopped using it in the meantime, but I think that those efforts can continue to move forward to see if we can get there. You know, part of that is connected with there have been litigation in other states against Google. I know Mississippi is one of those states where their state attorney general has filed a lawsuit against Google over their data privacy and school issues specifically. And so we'll see if that doesn't unclog that at some point. I know those efforts certainly continue. Well, let's talk about a few other tech issues out there, right? So we spent our first half hour really focusing on that data privacy piece. We've got some other school law tech issues that I think we need to also have on our radar. And one of those specifically is making sure that all of our online programs or other programs that we're using that are tech-based are accessible for students with disabilities. You know, I think a couple things that are out there for us. We've got House Bill 26 that makes clear that any third-party online curriculum has to meet the at least level, you know, AA of the World Wide Web Consortium's Web Content Accessibility Guidelines. But we also have had over time OCR similarly finding at the federal level, that's the Federal Department of Education's Office for Civil Rights, finding that requirement, you know, that things are accessible. So I think it is, you know, the change in the state law certainly puts some very specific parameters in terms of meeting that, you know, AA level accessibility, or the equivalent as it is updated over time. But that's been a long-standing issue, the web accessibility piece. You know, if you followed these web accessibility cases over the last several years, you know that there have been, you know, literally thousands of OCR complaints filed against school districts within the last 5 years, give or take, over this issue of web accessibility. Many of them filed by the same individual, I understand, but a significant number of those. And so it's certainly been an area that's on the forefront of compliance at the federal level, and we're going to add, you know, by next year that state requirement as well. The thing that I would certainly caution you about as we think that through is a lot of these third-party vendors will tell you in a sales pitch that they meet the accessibility requirements, but that doesn't mean they really do. And I think that that's an area that a lot of districts have started to, at least to me, express some frustration with, where they've entered into a contract with a third-party vendor who made some promises about accessibility, but it wasn't actually embedded in the contract itself. And it's hard to do that if it's not embedded in the contract itself. So when you're signing these agreements with these third-party curriculum vendors, you want to make sure that we are getting in the contract itself an agreement that they will meet those accessibility requirements, because, you know, ultimately OCR is going to require you to drop them, even if it means at a cost. If they aren't meeting the accessibility requirements. And so it is an important thing we can't overlook. And I think that goes to a lot of different issues that are raised in those accessibility guidelines, but ultimately that's there for us in a variety of fronts, right? Third-party online programs, our own locally derived remote learning opportunities, our website for members of the public, you know, all of those have to meet those accessibility requirements, and there's not really an exception for us in that regard as a public entity. So I do think it is important that we don't overlook that, and that's a factor that we have plainly addressed. And that's, again, always an evolving issue as well, as those requirements are updated and revised over time. So now, you know, in the second half of our conversation here, we want to focus on where things are going on the social media front as well. This has been, I think, one of the big sort of tech-related decisions in a long time. And the BL versus Mahanoy Area School District case certainly is one that everybody needs to pay attention to when it comes to student social media use and discipline. I think the court's decision here plainly sets out, some very specific parameters and guideposts around when it might be appropriate for a school district to issue discipline for off-campus speech. So let's talk that through. Great question popped up here that I'm going to specifically address when it comes to social media accounts that employees are using. So I see your question on employee social media use, and give me a couple of minutes to get to that point, because I want to address it directly, because you've got some great questions there that I think are right on par with what I want to talk about as well. So just to give you a quick background here, this is a case that arose out of Pennsylvania, originally out of the Third Circuit Court of Appeals. The Third Circuit back in 2020 found in favor of the student, which is not surprising. The Supreme Court ultimately did here too this year. This case involved a student who was a cheerleader who posted some crude messages to Snapchat while away from school, non-school time, in a convenience store called the Cocoa Hut with her friends. She was then suspended from the JV cheerleading squad for a year. She sued saying that violated her First Amendment free speech rights. And the court said, of course it did, at every level, right? The school lost, and frankly, they should have, right? I don't think this was frankly a close case in terms of the First Amendment jurisprudence that's out there to date. I think under the existing Tinker standard, the school loses, and they should have. But what makes this case interesting is the reasoning. And the reasoning of the Third Circuit was kind of way out there. And so I think that's why this case gets to the Supreme Court, because the Third Circuit really issued an interesting decision that kind of said it was hands off when it came to student social media use and school districts' ability to issue discipline. And but the Supreme Court, in an 8-1 decision this summer, again, ruled in the student's favor, but the reasoning is so important, right? That ultimately the discipline here, removing her from the JV cheerleading squad, violated the First Amendment because it disciplined her for speech that was protected, and that the school district did not have a legitimate interest in regulating. Now, the interesting piece here in the discussion is that discussion between, when does off-campus speech, including specifically speech done through technology or social media, when is it okay for the school to regulate that? Okay. And here the court said there are times where it would be appropriate, but the Supreme Court was very specific and really gave us 4 buckets, 4 categories of online speech by students that they said that may be a time when the school might be able to, not in every case, but might be able to discipline and regulate that speech without violating the Constitution. And those 4 categories are serious or severe bullying or harassment targeting particular individuals, so a cyberbullying bucket, threats aimed at teachers or other students, so that threat of violence piece, failure to follow rules concerning lessons, the writing of papers, use of computers, or participation in other online activities, so sort of a remote learning following the rules category, and then cybersecurity. So really those are the 4 categories. And they said, turning to this student's Snapchat conversation where she said F cheer, F the school, F softball, that didn't really fall into that, right? Now, the other thing that they said is there are 3 features of off-campus speech that diminish when our ability to regulate. And so I think that is important for us to recognize. And they say, first of all, when a student is off campus, we are rarely in loco parentis. And that is generally within the zone of parental control, not school responsibility. And I think in this case in particular, that's where the court said, hey, she was at the Cocoa Hut on the weekend. So if she had used the F word at school, talking to a classmate in the classroom, probably the school has an in loco parentis responsibility there to talk about her use of foul language. But when she's on social media, on Snapchat on the weekend, even though the message related tangentially to school or maybe even directly, but minimally to school, that was not sufficient to bring it within the school's zone of responsibility. Second, they said, and this is where I think they really put some additional parameters on our ability to discipline, is they said, if we let schools discipline for off-campus social media, that would pretty much mean that schools can regulate what a student utters 24 hours, 7 days a week. And they said, for that reason, courts have to be more skeptical of a school's effort to regulate off-campus speech. And when it is off-campus speech, schools will have a heavy burden to justify intervention. And so while they really are still saying we're applying that Tinker material and substantial disruption test to this case, they do it by saying, but it's a little more of an uphill battle for a school to get there, to claim that off-campus conduct would create such a material and substantial disruption. And then their third area is saying basically schools have to, as part of a public entity and being a nursery of democracy, protect unpopular ideas, and that's part of it. So ultimately, they said, taken together, in this case, an example where the school did not have an appropriate interest in regulating the students' off-campus speech, that there was not a material and substantial disruption of school, there was not a material and substantial disruption of cheerleading, nor was one reasonably forecast, and therefore, violated the First Amendment to issue discipline for her in this case. So, I think the bottom line here, and what we're going to look at is a couple cases where courts have, put in place this decision and analyzed new cases under this new standard articulated by the Supreme Court. But I think we recognize that plainly the Supreme Court's message is pretty loud and clear. When it's off-campus social media speech, we've got to really look at it more closely before we can just automatically assume that we can intervene. But there are times that we can't. And it really puts us in a tough spot, right? When we start talking about things like sexual harassment in Title IX, cyberbullying and our requirements under the school code of cyberbullying, we really do have some responsibilities there if it's within our jurisdiction. And so we can't just ignore it, but we're going to have to carefully analyze on a case-by-case basis what, if anything, we can do in those situations. So a couple decisions since the June decision of the Supreme Court this year that I think play this out. And we're going to talk about a couple others on a couple other related topics here in a few minutes, but the First Circuit Court of Appeals held just here less than a month ago in November, late November, that bullying is not protected speech, right? If we go back here, let me go back to this slide, right? That one of those four buckets was serious or severe bullying or harassment targeting particular individuals. And so the First Circuit held, in the Doe case out of the First Circuit, that the actions of the student were in fact direct bullying, and therefore were not rights protected by the First Amendment because they were serious or severe bullying that invaded the rights of others. And therefore, under the Mahanoy standard, they found that the school could issue discipline. And of course, we know under the Illinois School Code, we must at that point intervene and follow our bullying and cyberbullying policy when such a thing were to occur. So there's one case where the First Circuit Court of Appeals plainly found that cyberbullying did not fall within that protected piece. Another case here I just mentioned quickly, also from November of 2021. This case comes from the Southern District of Texas, from Katy, Texas. Kind of a different spin on this, but what I think is interesting here, just for points of our implementation of this, is the court would not apply the Mahanoy standard because they said this school district's decision was prior to the Supreme Court. And prior to the Supreme Court's decision in June of 2021, when this case was already pending, the school district didn't have the benefit of the Supreme Court's decision, and so they wouldn't apply it retroactively. And I think that's really interesting because the corollary implication is also important for us. Even though this court wouldn't apply Mahanoy retroactively to cases already pending before the Supreme Court's decision, it means we might be on the hook for things that happen now that decision is out there. So I think it is really important that we are actively looking at the these courts, the court decision here from the Supreme Court and how that applies, because we could be on the hook for violating a student's First Amendment rights now that we all are, now that it is clearly established, right? I think that is important. I see several questions here that are going to come back to sort of some points I'm going to make in a little bit. So if I'm skipping your question, it's because I'm going to get to that, I think, as it makes sense as we walk through these last few. But this latest question here, social media use on campus is different, correct? And I would say slightly, right? I mean, it's still going to be subject to that Tinker standard, right? Where it's going to have to be the material and substantial disruption. I think the key difference between on campus and off campus is this second prong here, right? Where that heavier burden to justify why we think there's going to be a material and substantial disruption on campus, maybe that heavier burden isn't there. But for social media use on campus, we're going to have that Tinker standard still going to be applicable. Now, if we're talking about the school's own technology, right? A school-sponsored speech, or vulgar and profane language in the school setting. And I think that's different than social media while on school, but in the school setting, like an official school component, then you've got different rights there under the various Supreme Court decisions over time. But I think social media use on campus is basically the same analysis, but without the same limitations that are going to be in place with that heavier burden to justify intervention. Relatedly, number 8, we've got to make sure that we're using our district's threat assessment procedures when we're handling online threats. This last couple of weeks has been a time where we've seen a significant increase in students doing and saying things that are being perceived as threats. And that tends to always follow when there's a school shooting like there was in Michigan a couple of weeks ago. And so we want to make sure we're not making mistakes like may have happened in that Michigan case in that regard. And so one of the things we need to remember is that anytime we've got a situation where something might be classified as a threat, including online, that the Illinois School Safety Drill Act would require us to use a threat assessment procedure in doing that. It creates a whole, I recognize that the Safety Drill Act seems like a weird place because it's not necessarily connected to the drill itself, but that's where the General Assembly in its infinite wisdom elected to stick it within the school code or within the statutes. But we know we have to have that threat assessment procedure. I also, while certainly not legally mandated, think it's important that we're also, as part of handling and managing and reviewing and assessing through our formal threat assessment process online threats, that we are also aware of and using the guidance that the U.S. Secret Service's National Threat Assessment Center have shared, including both through their July 2018 guide on threat assessments and their 2021 updated guidance on averting targeted school violence. There's some really important recommendations in there that our threat assessment teams and the folks serving on them need to be aware of. And one of the things that continues to be a concern for me is that we have forgotten that we have a threat assessment team when threats come up. And one of my biggest concerns is that we've got very specific policies and procedures we've adopted that lay out step-by-step things that the threat assessment team and related school personnel are going to do when presented with a threat. And one of my concerns is that if we have a potential threat situation, we don't follow our own policies and procedures that we adopted because we just shot from the hip instead of following our own policy, and then someone is hurt. That does raise a liability concern for me. So that's why it is so important to me that we are actively following our own threat assessment procedures that we've adopted when we have a threat situation, including an online threat. And back to our Mahanoy case, remember one of the exceptions the Supreme Court put out was a threat of violence would be a situation where a school district would have the ability to regulate and discipline for off-campus speech. That's what happened here in this case out of Pennsylvania, the AF case. Here they found that these particular posts to Snapchat were reasonably viewed to be a threat, and therefore were distinct from Mahanoy and were not protected by the First Amendment protections because they fell within that threat language, that threat category that the Supreme Court laid out, and that the school certainly could issue discipline for that. An interesting sort of case here where a school lost in a threat case. And this is kind of an interesting piece. You got to kind of follow the players here. So let me kind of slow down here. This is a case also out of Pennsylvania. So the student who's suing, the student JS, sent a meme to one other student, okay, student one. And that meme was a picture of a third student, student two, in which in the meme, student two is making statements about, again, this is a meme. They're trying to be, it's allegedly a joke about student two saying, I'm going to shoot up the school and those kinds of things. So the issue here is the student in question, JS, sends it to student one only. Student one then shares it broadly, okay? And the school expels, basically everybody here, but this is the rights of JS, who only sent it to one other person, didn't share it broadly, intended it to be a more private communication. And in this case, the court found that that was not a true threat, did not cause substantial disruption, and therefore could not be disciplined under the current First Amendment jurisprudence, including the Mahanoy area decision. Now, this is a Pennsylvania Supreme Court case, this is a Pennsylvania state case. This is not a federal decision. And so they did kind of take that sort of different true threat analysis that federal courts don't typically do in these student threat cases. But I do think there was an interesting distinction here between what did this student really do in terms of the disruption compared to what the other student did, and whether it was intended to be a threat or a joke, and the impact that it had. I think the court indicates here, maybe not directly, but more implicitly, that if this student had shared that broadly on Snapchat, that could have created a disruption that for which there could have been discipline, but because it was a one-on-one message, and it was the other student who sent it on, that the discipline here violated the First Amendment. So just an interesting case there. Now, the other related social media piece here, before we get to the school social media, and I know you guys have several questions about that. So what we're going to get to that here in the last few minutes is the extracurricular piece, right? The Mahanoy area case was about not a suspension from school, but a suspension from volleyball. So it clearly meets one of my, top rules of school law, right? You suspend somebody from school and they say, thank you for the 3-day weekend. And you suspend them from football or cheerleading and they say, let's go to the Supreme Court. So that's what's there. But remember, even when it comes to our extracurricular policy, we still have to apply Tinker. We all know the famous line from Tinker, right? That students or teachers don't shed their constitutional rights to at the schoolhouse gate, right? We all, have heard that one over and over and over again over time, but there was that less famous line that's also in Tinker, right? That the student's rights, therefore, do not embrace merely the classroom hours when he's in the cafeteria or on the playing field, right? It's right there in Tinker that it may apply beyond. And so we see those situations out there. So I think the first thing, just to come back to the basic idea here, that while yes, we have greater latitude, particularly from a due process perspective, in being able to issue extracurricular discipline, we still can't issue extracurricular discipline in a manner that would violate the First Amendment, right, or free speech rights. And so that's certainly an important piece to it. But one of the questions I've gotten frequently over the last almost 6 months since the Supreme Court decision is, well, does that mean we can't regulate any student off-campus speech through our athletic code? And the answer to that is no. It just means we can't discipline or regulate protected speech. And so we have to be ready to differentiate between what's speech protected under the First Amendment from other conduct that may not be protected under the First Amendment, even when we're looking at extracurricular discipline. And a case where that was front and center was the Cheeto case from Missouri. So this was a case decided in August, again, post-Mahoney, where the court undertook a lengthy analysis of the Supreme Court decision in reaching its conclusion. And this case involved a 13-year-old girl who, while at home on a Sunday, posted a video of herself drinking alcohol to her private Snapchat group. Other members commented. The student was later taken to the hospital. I mean, there was a lot going on here in the facts of this case, but ultimately this student was then suspended from athletics for a year, which prevented her from playing volleyball for the 8th grade. Okay. Now, part of how the school learned of this alcohol incident was through the screenshots of the Snapchat. But in this case, the court reached the conclusion that this student was disciplined, the athletic code discipline was for drinking alcohol, not for what she posted to Snapchat. And that even though the social media posts were part of their evidence of recognizing that she was drinking alcohol, the court here said that she was not suspended for her messages. She was suspended for drinking alcohol, and that is conduct that is not protected by the First Amendment, and clearly made a distinction there between pure speech and conduct that might not be protected. And in this case, a 13-year-old drinking alcohol, wouldn't be protected by the First Amendment, and therefore the district could issue discipline for that. So I think that's a really interesting piece in terms of recognizing where courts are making that distinction. And then finally here in my top 10 list, those legal issues that are inherent in district operated social media. And I know I've got a couple questions here on this already, so I suspect you guys may have some other questions on this. But remember, when we create a social media account for official school purposes, we're using it for school purposes only. We're not cross-contaminating that with personal posts. So, for example, if you've got a teacher or a coach that's using it to connect with their athletes on the team, but if they're also using it for their personal use, we get some real weird First Amendment issues there. Like if students are following this account because of a school activity, but then that coach is also posting religious messages, for example, we may have an entanglement or a religion issue under the First Amendment too. So we've got to be careful about that. And courts have been, pretty plain in this view. Now, the case that I think is most directly on point is the case that involved former President Trump. Now, this case was vacated as moot by the Supreme Court once President Trump was no longer president. But ultimately, the Second Circuit Court of Appeals had held that the president couldn't block people on Twitter because it was being used for official government purposes, and that creates a limited public forum. And the same analysis would apply to us, right? If we are creating a social media account for official school purposes, then it's likely a limited public forum, which means, we have to have a content neutral, regulation of speech, and be careful about who we block, if we can even block people, or deleting comments and all of that. So, I think a couple points here that's even been an issue under FOIA, where we're trying to determine who was the actual banned or blocked, that those are public records that would have to be turned over in a FOIA request. So we've got to really think about the extent to which we can regulate if they're if we're allowing comments at all. And I think that's where we've got a couple questions here that I want to come back and think about in that regard. So, are districts liable if an issue surfaces from a social media account like Facebook, Snapchat, et cetera, that a teacher or coach uses to connect with their students or athletes? The answer is yeah. If it's being used for an official school purpose, then we could be liable for anything that's happening. If they're using their personal account to communicate about a school activity, I don't think it's a personal account at that point. And it could be subject to FOIA. We could have FERPA considerations with, that question 4 here with protecting confidential student information. Does that platform meet SOPPA and data privacy requirements? Are we violating other things like religion, boundary violations, which is going to be a big training going forward with faith law signed by the governor this month? Those things are out there for us. So I do think it is really, we've got to be careful about that because there is liability. Second related question here is it allowable to delete profane comments that are posted on a district social media channel, or is the comment considered public record? Well, the answer to that is probably both. Because we're creating this limited public forum, we can place time, place, and manner regulations. So if somebody posts something that is truly profane, I think you have the ability to regulate that because it violates your rules that you have in terms of using vulgar or profane language. However, we can't delete something just because we don't like what it says or because it might be critical, right? We're going to have some very specific rules. And that's where I think it's important to come back to say, recognizing what we can regulate. I think it would go back to that basic sort of Tinker standard, material and substantial disruption, threats of violence, cyberbullying, threats or harassment targeting individuals, vulgar and profane language in the school setting. Those are things I think we can regulate. And so I think part of that is also alerting the public to those expectations. So find ways, either, pin it to your district's Facebook page or other places in your handbook that have those expectations for conduct on the district's social media page. I think that is an important piece to it. I also think, we are also creating a public record there potentially, as we saw here under this PAC opinion from last year, saying that the list of people who had been banned or blocked from the social media accounts was a public record that had to be turned over under FOIA. So recognizing those things there for us as well. A couple other questions on this front. For our social media pages that are district approved, do we need an archiving system? And I think the answer to that is possibly, right? I think there's two different issues that pop up. One, obviously anything that's a student record has to be maintained, but we really shouldn't be using social media-based pages for student records under FERPA or the Student Records Act because it doesn't have the data privacy requirements inherent for student data. So I think that is an important one that we need to keep in mind. But we may also be creating local records that have to be maintained under the Local Records Act. Outside of, they have a definition of what are transient records, but I think that there may be a requirement there as well under the Local Records Act to maintain those electronic records. Another question, what's the district's responsibility, or what's the district liability for social media use or communication platforms that have not been approved by the district, but are being managed by district personnel or others like a parent? Well, we do have responsibility for that, ultimately. So if we are, if we've got a coach or a parent organization that for official school purposes is using something that is not approved and not compliant, then the district is ultimately the liable party for that. Maybe there's some situations here where there's discipline or possible liability for that individual, but ultimately the district is responsible for making sure that all of its employees and volunteers are using district approved channels for communication that are appropriate. And if somebody is not, then we have to be aware of that and follow up. And so that's why, the SOPPA compliance piece is not a one-time issue, but something we've got to keep up with over time to meet that. So I think that's important for us. So bottom line here on district social media, you can't delete comments just because you don't like them, or you're creating a limited public forum. So we have to treat it as such with all of those First Amendment protections that come with it. And the best way to avoid all the negativity is to fill it with the positive, right? Be good models and share what's there. Question, what about parent-led groups? Well, I guess the issue is that parent-led group still a school, club, or organization, or are they entirely separate? Because if they are being supported, sponsored, or run through the school, then I think all the same requirements going to apply as would to the school. But if they're a purely private, separate organization, the school has no involvement, no sponsorship, they're not handling anything, then I think it's a different answer. But if it is a school sponsored or school related parent-led group, then I think that is there. So if the question is, parents make a football page for communication and are using the school logo. I mean, that's where we've got to be careful. We've got a policy about when we would allow people to use our logos to avoid that type of consideration. I think if parents have that separate football page for communication, I think a couple things need to happen. One, that we require that they put on there that it is not school affiliated or school sponsored, and that the school doesn't then do that, right? So our coaches shouldn't then be participating in that parent page, because if they do, I think that converts that to being a potential school related page. And I think that has other considerations for it. Well, we've made it through my top 10 list, and we are right at 3:32, but I'm happy to take the questions you guys have. So if you've got other questions, please pop them right here in the chat box, and I'm happy to answer them or talk through whatever else you guys have out there. But I know that so much has been going on at once, right? This is such a hard time for all of us. And I recognize hearing a lawyer talk about the things we must do and the rules and all of that can be overwhelming. And my intent is really honestly not to overwhelm you, is to try and make sure these things are on our radar so that as we're encountering them, in our daily lives at work and at school, that you've got Brandon's voice sitting there on your shoulder saying, we know what the right thing to do is, right? That's what we want to be thinking through. So thanks for hanging out this afternoon. And again, happy to take any questions. If anybody has any questions here before we finish.
Yeah, thanks, Brandon. We'll go ahead and pause here. If you have any other questions, throw them in the Q&A or in the chat. But I just want to say thanks again for joining us. Your sessions are always great. I learned so much from them. And like you said, there's a lot to it, and we just appreciate you joining us and sharing the information and being kind of a part of our series here. So go ahead, if you have any questions, we'll just take a pause here and throw them in the chat or the Q&A, and we'll be sure to get them answered.
No, I appreciate you guys having me, and always great to hang out a little bit and share some of the things we're encountering out there. So I think that's important.
I can take this one, I guess. As far as LTC, we do have some trainings on social media use. I know Nicole Zampano, who's the director of instructional coaching, has done several sessions on just utilizing social media for the good, and some things to avoid as some good overall pointers. So I don't know if there's anything. You can always check out our events page, ltcillinois.org/events, to see when they're coming up. I don't know of one off the top of my head, but that's one that we've done in the past to help them kind of think through how to use social media in their classroom in ways that avoid needing to to have any difficult conversations. So
to avoid having to call a lawyer. Right.
Yeah, exactly.
All
right. Well, I think that unless I see a question come through here in the last couple of seconds, we'll go ahead and wrap up for the day. Again, Brandon, thank you so much for joining us. Everybody, thank you for joining, and we will have this recording up available for you by the end of the day tomorrow. So check our YouTube channel for that recording, and feel free to share it out with anybody else in your district you think might benefit from hearing the message. So again, Brandon, thank you so much, and hopefully we'll see you again real soon.
Thanks so much.